Welcome to today's presentation on Healthcare Reform's Age 26 Coverage Rule. The Healthcare Reform Law expands the coverage that is available to dependent children under employer health plans. If your health plan provides dependent coverage, your children must be eligible for coverage under your plan until they turn 26. This is the case whether your plan is considered grandfathered under the Healthcare Reform Law or not. However, if your plan is grandfathered, it does not have to make this extended coverage available to a child who is eligible for other employer-sponsored health coverage, such as a plan offered by his or her own employer. While the plan or health insurance issuer is required to make this coverage available, actually covering your child under your health plan is not mandatory. Parents have the choice of whether they want to keep their child on their coverage, and children do not have to enroll in a parent's plan. Keep in mind, however, that the individual mandate requiring most individuals in the U.S. to have health coverage or pay a penalty is scheduled to take effect in 2014. Under the coverage expansion, the eligibility rules for your health plan are restricted by federal law. Now, eligibility for dependents in plans that offer dependent coverage may be based only on the child's age and the relationship to the employee. If the individual is under 26 years of age and is the employee's child, he or she must be eligible for dependent coverage under the plan. Many plans used to consider a number of other factors in determining eligibility for dependents. Examples include whether the child was financially dependent on or lived with the employee, and whether the child was a student, was unmarried, had a job, or was covered under another plan. The definition of who is considered a child for purposes of dependent eligibility is fairly broad. A child is either a natural child, a stepchild, or an adopted child. It's not quite clear, however, whether foster children need to be included. The coverage that is offered to these adult children has to be the same as the coverage offered to other similarly situated dependents under the plan. Employers cannot offer one set of benefits to adult children and one set to dependents under 18, for example, just based on age. You may have to pay a higher premium to add dependents to your plan if you need to move from single to family coverage, but you cannot be charged more for adult children than you would for other children. Keep in mind that some states require coverage to be offered beyond age 26. Those laws will continue to apply, although the federal standards must be followed until the child turns 26. Also, federal tax law has been revised so that your employer's coverage for these dependents is tax-free until the end of the year in which they turn 27. Most state laws now match the federal law. However, if your state requires coverage beyond age 26, or your state tax law has not been revised, you may have to recognize additional income related to this coverage. Thank you for viewing this presentation. If you have questions about coverage for your adult children, please speak with your plan administrator or HR representative.